Good afternoon and welcome. My name is Banaz Mansouri. I'm a senior attorney with the Unemployment Law Project. The Unemployment Law Project has been around since 1984. We are the only freestanding legal organization solely dedicated to unemployment. The Unemployment Law Project provides free advice and counsel and free representation to people in Washington state who have been denied unemployment benefits or whose award of benefits are being challenged. We're here today with our weekly webinar, which occurs every Monday at noon. The purpose of today's webinar is to share the latest news on unemployment benefits and to answer your questions. We'll share some commonly asked questions, and I'll also be monitoring your questions in the chat box today. I'd also like to draw your attention to this Thursday from 6 to 7 p.m. We'll be hosting our annual Brew Review fundraising event. We'll be online this year. I will post a link in the chat box if you're interested to purchase a ticket and join us. It's going to be an exciting event. We'll have live music from the DIP and great speakers. I'd like to introduce our speakers for the webinar today. From the Unemployment Law Project, Executive Director John Tierpak, and Staff Attorney and Policy Director Ann Paxton. I'll turn it over to you, Ann.
Thank you, Banaz. Welcome everybody to our latest webinar. And please don't forget, since I may forget at the end, about our Brew Review on Thursday, big event for us. We've had some online events. This is an online event before, and they've been very successful. So we look forward to seeing you there. So just to wrap up what is going on in the world of unemployment insurance. So the big news, of course, is that lost wages assistance is over. That was all those payments have been distributed only through, that was to compensate for the end of the PUC as of July 31st. There were 6 weeks of benefits that went out to people who qualified between the end of July and the middle of August. And those, there was about $624 million. So not a small amount, went to 430,000 claimants. Of course, it was only a fraction of what would have been received if the PUC had been extended. So there is still hope that some kind of extension might be passed by Congress at a later point. I wanted to make a few points about the economy right now, just in the context of what's happening with unemployment nationwide. So since March, there's been 58 million people in the country who have filed for unemployment. It's kind of a shocking number. And the IRS is now predicting that the US economy will have almost 40 million fewer jobs in 2021 than they predicted before the pandemic. And that's a result of a prolonged recession here. And the really high impact part to keep in mind is that studies have shown that about almost half of the US employers who have furloughed or laid off staff because of COVID are considering additional workplace cuts in the next 12 months. And of course, the employees who are likely to be hardest hit by that will be the low paid workers. And about 50% of all small business employees who were furloughed since March are still without work. And 28% are still furloughed. So if you notice the worker adjustment and retraining notifications that come from the Employment Security Department, they're changing from temporary layoff to permanent layoff. And we're seeing that among quite a few companies. And most notably, most recently, Boeing is going to be a very big factor in upcoming months and years. So it's very concerning that one of the Census Bureau is reporting that 1 in 5 working age adults is unemployed because of COVID, because COVID upended their childcare arrangements. So that is having a very hard impact on women, who are 3 times more likely than men to have to leave their jobs, because they tend to be responsible for more of the caregiving. And they're up to 5 times more likely to have their hours decreased to take care of children. So that's the broad context. In Washington State, the latest status report we have from the Employment Security Department was given to the Senate Labor Committee last week. And this was on what is happening with the delays in claims, what's the status of appeals, and other issues that the Employment Security Department is focusing on. So about 1.3 million people in the state have applied for benefits. That's a third of our workforce in Washington. And of those people who applied, 76% have received at least some form of payment. And ESD is being a little bit fuzzy here, because when they say some form of payment, that may mean only 1 week before they were terminated from benefits for whatever reason. And many of those people have not had their benefits picked up again. So, but that is what ESD is saying. 76% have received some form of payment. They've also said that there are 26,000, almost 27,000 claims that are still in the adjudication process. We have no update on the appeals that have been pending as well. We understand that about 7,000 appeals were transmitted from the Employment Security Department to the Office of Administrative Hearings in September. So that is a big step up from prior months, which were sometimes less than half of that quantity of appeals being relayed. But it still falls well short of the number of appeals that were filed. So there are many appeals that are still pending at the Employment Security Department, where they've decided to reassess them, either because they've gotten new information or because they just don't want to send them off to the Office of Administrative Hearings. So we're waiting to get more clarification on what exactly is going on there. We've been waiting for quite some time on that. But there are quite a few thousand appeals that are there as a result of the September transmissions. I wanted to make a note about identity fraud, because ESD is stressing that this is something that's going to be ongoing and is going to cause continuing distress to a lot of claimants. Over the last 2 years, they said there have been about a 400% increase in cyber attacks. So that is what they're saying is one of the major motivators for having these very strict fraud measures that they're taking. They're saying criminals are really taking advantage of innocent individuals who are more in need of digital assets than ever before. And so this is part of the explanation for these more onerous ID requirements, which have been causing a lot of delays and a lot of stress for claimants. They're allegedly due to very sophisticated imposter IDs that are simulating actual claimants. So another issue that ESD mentioned was automated backdating. When the CARES Act was passed and pandemic unemployment assistance came in, there was a promise that if you had trouble getting through because of the volume of claims being filed, or for any other reason, if you had a legitimate reason to apply for benefits under pandemic unemployment assistance, that your claim would be automatically backdated. So they did that for a while. They promised it, they did it, but because of the, they're saying because of the fraud and the identity issues, they've had to cancel the automated portion of that. They're still promising to backdate, but what happens is when somebody needs to backdate their claim beyond a reasonable amount, they have to call and verify with ESD why they need to do it. So they've added another pain point to the process, and that is going to be the topic of most of the rest of what I'm going to be talking about today. I wanted to mention that the ESD told the Senate committee that there are going to be 3 audits. The state auditor was in fact there at this briefing and said one audit is going to be on imposter fraud, which was the massive criminal enterprise that took out several $100 million from the state. The second is on ESD timeliness of benefit payments. So this is obviously a big concern to us and to claimants. And finally, responsiveness issues when claimants seek help. So the auditor said the 3 general things we're trying to understand are the nature, size, and causes of the fraud, what's happened with timeliness of benefits. Obviously, there's been some delays for many people, a masterpiece of understatement. And then what's gone on with regard to lack of responsiveness to claimants. So it is good to know that the auditor is going to be taking an independent look at this, and we hope we'll have some recommendations going forward. So I mentioned pain points. This was the topic of the Employment Security Department's a briefing to the Unemployment Insurance Advisory Council. This is a new committee that's formed of it has 4 representatives from the business community. It has 4 representatives from the labor and worker advocacy community. And they've been meeting quite frequently, once about every 2 weeks. So this is at least one example of where ESD has cranked up its efforts to at least appear more responsive to concerns out there in the field. So their topic on September 30th, last week, was various pain points that from the claimant experience, the claimants are experiencing, and that the measures they're taking to address them. And I won't say that these are exhaustive and ultimate solutions, but they are addressing the issue. So I wanted to let people know what their standpoint is on the kinds of issues that we're hearing from people are still causing a lot of troubles. So first pain point, many customers do not have meet the requirement of availability to work, but they may still be eligible for pandemic unemployment assistance. The problem is the ESD systems has never been set up to easily pivot to these new requirements. It's always been set up to say, if you're not available to work, you can't get benefits. But now there are reasons why you can get benefits. For example, if your children's school is closed, if you're sick, if you have to take care of another member of the family with COVID. So this has been a temporary reality that's brought in by the pandemic. They said its PUA was dropped with fairly short notice because the pandemic just swooped in and unemployment just went off the charts. So as a result, customers are often, I'm telling you what they're saying, customers are often frustrated by being asked repeated questions, but they do need to be confirmed each week. ESD is required to verify the type of occupation that claimants can enter an open text response on the forms to explain reasons why they might not be able and available to work. And in Washington, we have this payment of conditional, we have this system of conditional payment, which is very controversial because it often ends up resulting in an overpayment for many claimants later. Second pain point is monetary determination. And this is an issue that ULP has been fighting ESD on for some time, and it has to do with the lawsuit that we've been involved in regarding this issue of monetary determinations. It's related to our lawsuit. That is what happens when you apply for benefits and they say you don't qualify, but you haven't gotten a denial yet, so you can't appeal it. What it usually means is the employer has not, what it often means, the employer has not supplied evidence of your work history, so they don't have a starting point for saying that you're eligible for benefits, but unfortunately they have not set it up so that is an appealable decision. Their internal software is set up to use templates on their letters, and unfortunately these kind of cobble together a lot of different messages that don't quite work together. So they call it populating with drop-ins. That's the technical term, but the term for the person who's trying to read the notice is, I don't understand this at all. We get quite a lot of that. You get, here's your weekly benefit amount. You've been awarded a weekly benefit amount of 0. It's a very confusing message, very big pain point. One key reason, as I mentioned, is the lack of unemployment records from the employer, and that has to be investigated, and it's tending to take a long time. We have a lot of people who've gone 6 months with a negative monetary determination, have never been able to figure out how to successfully change that. And there are different monetary determinations for regular unemployment insurance and for PUA, so that adds to the complications of this. So another area that we often hear about from people is separation issues. For example, you may have had an employer 6 months ago say that you quit the job, but then you took a new job and you were separated from that job, you were laid off, and a perfectly straightforward reason to collect unemployment benefits, but the prior separation is causing a problem. So what ESD says, because they're classifying you as a voluntary quit, which requires additional demonstration that you're eligible. You have to have a good cause for quitting in order to collect benefits. So ESD's comment on this, and at least they are trying to address these issues that have been brought up so frequently. So we do want to give them credit for that, even though it's not where we hope it would be in terms of responsiveness. They're saying if there's a separation, they need additional information to determine your eligibility and with follow-up. And they have what they call timely re-engagement with the claimant that is necessary. They're trying to improve the customer experience. We do somewhat object to the term customer because it implies that ESD is a business when it's really a source of a benefit that people have earned through their work. We would prefer they use the term claimant, but so I'm going to try to use that in my briefing on what they've said, even though they use the term customer. But their goal is to reduce the answers that delay resolution of the problem. They're in the middle of a process to identify places where there's confusion, and they're trying to get to the point where they can avoid more adjudication. The main explanation for this problem with voluntary quit versus a recent layoff is that in order to, quote, purge, it sounds like you're trying to get rid of a bad character trait, but in order to purge having had a voluntary quit, you have to have 7 weeks since the separation, and you have to have earned 7 times the benefit amount. Otherwise, you get disqualified. If you cannot purge the voluntary quit, then they have to go to adjudication, which is most people here have experienced is not a pleasant process and can be very long drawn and never really reach a point of resolution in many cases. Pain point 4 is the work requirement. So ESD stopped requiring a job search in June, and that job search suspension, by the way, was just extended to November 12th. So you're not required to look for work. That doesn't mean that you don't have to be available to work, except for those 2 instances, those 2 or 3 instances under PUA. You do have to be available to work. You have to be ready to accept a job if you're offered, if it's suitable work. But it's not straightforward business for ESD to just turn off a letter that says you have to do a job search. This is what ESD is explaining. Their software is set up because that is kind of a bedrock requirement of unemployment in general under normal circumstances. So it's very hard for them to just turn it off. They don't send a letter anymore saying you have to do a job search, but they still do ask on the weekly claims whether or not you completed your job search. So they have promised that if you answer this honestly, you will not be penalized because you're not expected to look for work. But as John has mentioned many times, it doesn't hurt to look for a job for many reasons, but one of them is if you want to honestly say that you've done a job search, it doesn't hurt to get three search targets into your claim in order to avoid difficulties. One of a reporter that we heard on a webinar today was talking about her own experience, and it was very interesting in trying to deal with unemployment in New York State. And she said it was my 98 days in unemployment purgatory. And she thought it would be simple because she had been laid off. Oh, sorry, excuse me. She thought it would be simple because she had been laid off. But what happened was there was I got distracted by this phone call. So there were a lot of arbitrary elements, and she ended up calling the governor's office, Governor Cuomo, and Governor Cuomo actually patched her through to the Department of Labor in New York State, but the computer wasn't working there, and she spent several hours on hold. But the problem was she had said on the application they had asked her in the claim, was your office or your workplace closed because of COVID? And she said, well, I have to say no because I was laid off, but my workplace didn't close. And so once she did that, her claim automatically went to adjudication, which, as we all know, is close to not an unsuccessful claim. So the agent that she spoke with would not see any flexibility in the way that you answered that questions. And when she followed up on it, they said, well, you sort of overinterpreted the question. What we really meant was did you lose your job because your employer had a COVID problem. So this is just one example of how there's the stakes of lying on a claim or in any dealings with an employment security department are high. You don't want to be caught telling an untruth, but this is an example where the system really wouldn't accommodate the truth. So it was kind of interesting because we have heard of a lot of cases like that happening here in Washington. So I mentioned verification of identity. What ESD has said is the claimant must wait for us to verify their identity before they can issue payment in almost all cases. So that's why people are feeling very harassed about this. They say they're trying to avoid giving a blueprint to criminals, so they can't really explain the reasons, but they have many motivations for asking to verify more than once. So that is why people are getting the experience that no one is hearing me because I've sent my ID several times. And their explanation is that if they receive information that leads them to question whether they should trust the claimant, they have to re-verify. They say, we are not doing this frivolously, working on improving the data and the tools used to set those identity issues and our communications. So the moral here is I think identity verification is going to continue to be a pain point for claimants. And generally, the whole CARES Act has been a pain point because the system was not built with the CARES Act in mind. It had to crank up very fast for it. And the rules have been changing all along, and they're continuing to change. So one of the most current set of changes has to do with this switch off between regular unemployment benefits and PUA, because it's possible to qualify for regular benefits and then have to re-qualify for PUA, and then maybe have to go even back, because the default is supposed to be on regular benefits. If you qualify for that, you can't get PUA. But many people can't qualify for regular benefits, then they have to go to PUA. So their status may change. Another issue that arises because of the CARES Act and because of these different programs that are going on is that you may get a notice that says, this is the final payment of your current entitlement, but it does not necessarily mean that the extension programs aren't available, but it won't necessarily say that. So if you log in the following week, then you might be able to file another weekly claim, and it will process under the new benefit program. Like extended benefits, for example, are one instance. But they want to let us know that, let claimants know that if you can file another weekly claim, and it will process under the new benefit program, even if it didn't warn you in advance. So that's an unfortunate aspect of it. The final payment status may not necessarily be the end of the story, so not to necessarily be alarmed. They say they're adding an additional letter to help people through that process. So when you're approaching the final payment of regular unemployment insurance, that you'll have the information you need to successfully navigate through the extensions. And then finally, I just wanted to mention about language access. The Employment Security Department has several new team members. About 2/3 of the new people they've hired are now focusing on language access. And so what they call a tentpole feature of their program to deal with people that have limitations on their English is by having a translator being available to come on the phone. But as I say, when call volumes are high, these claimants experience the same challenges as everyone else. And the need for an interpreter makes it more acute for them. They are trying to add more agents to deal with this. And they also say they're launching a callback system to help in the short term. However, this is something that we would like to see, very much like to see a callback system set up over the long term, because it is such a problem for people to keep calling and calling with so little effect. And there was a new report that just came out literally this morning from the National Employment Law Project on modernization of IT and unemployment benefit systems. And this was one of the points that they made, that in their recommendations, they did a nationwide study. And in fact, they came to Washington State to talk with our ESD and to the Unemployment Law Project with some of our claimants that we have as clients. Their recommendations are: first, unemployed workers need 24/7 access to online and mobile services, and especially mobile, because that tends to be predominate as the main technology that people have out in the field. Most people do not have laptops they can rely on. So unemployment websites also need to be mobile optimized. We've had different reports on the level, whatever level our state is at in that respect. States can use callback and chat technology to deal with the unprecedented volume. And we have really been trying to urge Employment Security Department to look at a better method to keep from having to tell people you just have to keep calling back. That is extremely frustrating to people, maddening really, because of the lack of certainty that you're going to get any response, no matter how many times you call. So at the last meeting of the Unemployment Insurance Advisory Council, and I want to mention this because it's something that you can do if you also are feeling frustrated about policy. At the end of this meeting, and it is for committee members to participate in, but at the end of the meeting there is public comment. So the Unemployment Law Project was able to submit a comment saying that this is creating such a level of frustration and despair among claimants that we feel it is an emergency that they really need to address. People should have some assurance that when they call, that is going to register at some level. So whether it's an automatic callback or some kind of register, there should be some recognition that they have made an attempt, and they should be put in some kind of queue. And obviously there are a lot of logistical issues here, but it has to be a priority because this lack of confidence that this creates in the system. This is really the gist of our comment on Thursday at the committee meeting. Is very destructive. It's very destructive to people's morale and to their ability to go on and to feel that they have any reason to keep applying for benefits when they should be, because they're such an anchor for not only people's families but for the economy in general. So we feel even if the claimant hears that they might be the 25,000th caller, but at least they know they've registered in the system and that somebody may get back to them at some point. So we would like to see a transformation in the telephone policy. So that was our comment on Thursday. I want to recommend that you get in touch with go to the website esg.wa.gov, and you can look up. Sorry, Benaz, I tried to do this before the webinar, but it's under UIAC. Is the abbreviation for the committee meetings. It will give you the Zoom link. You can go to the meeting. It's usually Wednesdays. Every 2 weeks. I think the next one is October 14th, from 10 to 12. And at the end of the meeting, you have a chance to do public comment. So this is a very worthwhile thing to try. At least you can get, one of the things you hear from legislators all the time about why haven't they done this? Why haven't they done that? They'll say, well, nobody told me about it. And so at least you can be sure that isn't happening. You have a 2 minutes to say your piece. Should be related to policy as much as possible, but let them know what's going on out there. They may sometimes just not be in touch enough to really appreciate what people are going through. So that's the news for today.
And I have a few additional comments. Just on the issue of job searching. Yes, it may be a good idea to job search, but be very careful to not be applying for jobs you either don't want or can't do. Because even if you're not required to look for the job, if you turn it down, that's a question on your weekly claim. So if you're only able to do remote work, only apply for that. If you have a strict geographical limit, only apply for that. If there are money considerations that are important, be careful not to apply for jobs that are way out of your range, because that could be a problem. The issue of the backlog of claims and appeals, we've been having periodic meetings with people from the Office of Hearings, Employment Security, and Office of Civil Legal Aid to move these issues along. I think they've been productive so far. And also, just on the issue of further advocacy, whether it's you or one of your clients or someone you're working with or a friend or family member have these ongoing issues, feel free to write to the governor's office, send an email, call and email your state senator and your state representatives, because a lot of people are, well, there's an impression out there, I've been hearing, that things have been resolved, that because certain number of claims that were in adjudication that were backlogged have been taken care of, and that there has been some progress made, that somehow the crisis is not over. And I'll say, from the number of calls we get each week, the crisis is still ongoing. So please feel free to contact the governor's office or your state senator and representatives.
Also, just to add one other thing, we do get a lot of requests from reporters for claimants that they can interview on certain subjects. This week, it is overpayments, for example. They would like to talk to people who've been hit with an overpayment, and I know there are a lot of them. If you're willing to talk to a reporter, that could be of great help to you as well as to others. Last week, they were interested in talking with people who might have been fired because of having COVID. So there are any number of reasons why a reporter would be interested. There have been a lot of stories about unemployment benefit problems. So this is another way to sort of mesh into the solution path on having these issues addressed.
Great, thank you both, Anne and John. I dropped a bunch of links into the chat box. So take a look there, everyone, and we'll continue to provide information in the chat box. We have quite a few questions, so let's get into it. If a case is under adjudication for PUA and the monetary determination so far is $0, should an appeal be filed before the conclusion of the adjudication?
If it's in adjudication, usually there has been a determination, I believe, because John, correct me if I'm wrong, but I believe it's called a reconsideration before you actually get, if you haven't got a determination. It might be an adjudication. If it's difficult to appeal without having a determination. John, maybe you can address that better. Yes, it's unfortunate. There's two stages that it's a very complicated process. First, monetary determination, and that depends on your employer providing accurate information about your employment, your work hours, and your pay. And many employers fall down on getting this information incorrectly. So that's a real obstacle for people. But in order to get any consideration on, in order for your claim to proceed, you have to get past the monetary determination. If you don't have an actual appeal, you might consider getting in touch with us, and we might be able to give you some advice. This is the subject, in fact, of the lawsuit filed by the Northwest Justice Project, because what people get is what they've termed a non-denial denial. In effect, you've been turned down, but you don't have an actual thing that you can appeal. This is a really big hole, a really big gap in the whole justice system in administration of benefits. So we're doing the best we can to get attention to this, to get some legal action on it. In the meantime, a lot of people are struggling with this. So you might want to get in touch with us and see if we can give you some advice.
Great, thank you, Anne. We have a few questions related to PEUC, which is the extension of timeline for benefits. When filing for PEUC benefits, some people are being asked a short set of simple questions, while others are asked to provide a detailed work history. Oh, hold on, that question disappeared. Others are being asked to provide a detailed work history similar to filing a new claim. Do we know why the difference in, why the discrepancy?
I do not know. there could be so many reasons why. ESD has made the point many times that new information comes in that may cause them to take a different viewpoint on your claim than they took before. So this is an issue that I really can't explain why that would be happening. You do have to qualify. The rules for qualifying to receive PUA as well as PEUC have gotten more stricter. So that may be part of what's happening, but I can't really speculate more than that.
Okay, great. Some people report being awarded PEUC benefits in the amount of their previous weekly benefit amount. Unemployment is aware of this issue and says they are working on it. Do we have any news regarding this problem?
So I'm not sure I'm understanding. They're getting the same benefit, but what is the question? That would be what I would expect, actually.
That's correct. So I'm having a private chat with the individual who submitted the question, but I just wanted to raise it here in case you had any additional information. My understanding, and confirm this for me, Anne, please, is PEUC is the extension of the timeline for which benefits are granted, but it does not necessarily alter the amount of the weekly benefit amount.
It shouldn't. However, if you have to switch to PUA for some reason, your benefit could be cut back very easily. Maybe they don't have the documentation to show. If you're self-employed, for example, they may not have the documentation to show your income, in which case you would get the minimum benefit of $235. So I don't know if that's what's happening there. They may have suddenly gone into a PUA benefit mode, in which case their PEUC was also cut back. But yeah, I can't really speculate on that.
Okay, well, we're going to chat offline. I wonder if also the elimination of the $600 additional benefit might also be what's causing that difference, or the
Right.
loss.
It's been very confusing because there was the 600, then there was the 300, but everyone didn't qualify for that. You could only get it if you had a COVID-related reason. And then another thing that happens is people, when they get your final benefit payment, it won't necessarily be the full amount. You may have bumped up the limit on your benefit for that year, that benefit year, in which case you're only going to get a partial payment. So I've seen a lot of questions about that. Why did I get, $450 last week and this week I only got $250? That might be one reason.
Okay, great. For workers already on the state's extended benefits and who are covered by a hiring hall agreement, how does the job search requirement work? The live events industry is closed. Are they required to look for work outside of their industry when the requirement is reinstated?
So if it's a full referral union, you should be okay. No, of course the job search is still suspended, so you're fine for now. When it kicks back in, actually the Employment Security Department, the governor requested that it be job search be suspended until December 1, and the legislature chose November 12th. So I think it's probably going to continue being extended, but there's no guarantees there. John, are you back? This is a question about hiring hall and the need for a job search. I'm not sure he can hear at this point. So yeah, I don't know, but for right now, it should not be an issue, at least till November 12th.
Okay, great, thank you. Let's see, we have a participant who received an overpayment notice on Friday. ESD said it was their fault, the claimant's fault, and it took them 3 months to make this decision. Also, there was a week in June that the claimant was not paid for and found out later that they should have been. What should they do at this point?
So that's a complex fact pattern, right? so they're saying they actually are owed more money than is accounted for in the overpayment. That I'm not sure I understand, but.
Yeah, I think they received an overpayment notice on Friday. ESD finally made their determination. It looks like it's going back about 3 months. It seems two things. One, I think the claimant is contesting the overpayment, and if they are successful, there's 1 week that they had not been paid for during their weekly claims. So what should they do I mean, I'm guessing it's an appeal situation, but.
Yeah, I'm going to assume it's an appeal. Obviously, you would want to appeal the overpayment. If you don't win that appeal, you can apply for a waiver unless it's PUA, in which case they don't have waivers. So, but do appeal either regular benefits overpayment or PUA overpayment. And I'm not sure that I'm not sure what the process would be for missing a week. That sounds like one of those situations where you need to get on the phone and to talk to an agent to start with.
Yeah, I think when a claimant is successful in winning an overpayment case, then ESD does go back and make the corrections automatically. If they don't, then that is an opportunity for the claimant to contact ESD through their SAW account. Usually messages have more success than reaching someone over the phone.
Thanks.
Okay, let's move on. Are we required to report 401k withdrawals as income? One of an individual withdrew from their 401k account to pay their property taxes, but they're unsure whether that classifies as income or not. They're over 65 years old. What is the recommendation?
So I don't believe you have to, I don't believe that should affect your benefits, whether you should report it or not. If you, I can't say. I'm going to have to defer on that because John knows more about this.
Okay. This is the same claimant that I'm working with on the union issues. So she and I'll talk about it directly afterwards. We'll get some more information for her. Okay, we have a participant who filed an appeal on August 12th. They received payments for about 6 weeks. They quit their job because their son lost childcare. And then their payments started getting disqualified because ESD had received information from the employer that 1, they had quit, and 2, they were taking care of their child. Our participant is perplexed because that's exactly the reason why they thought they would be eligible for benefits in the first place. First question is, do we have any idea on what the turnaround time is for appeals being scheduled with OAH? And second, does the conditions for which the individual left work make them eligible or ineligible for unemployment?
So it's always difficult to answer this because it depends on whether you're getting regular benefits. You can't qualify for benefits because you have a child care issue if you're getting regular benefits. That only works if you are receiving PUA, and only because of a COVID-connected reason. So the first thing is, are you getting PUA? I'm going to assume the person is getting PUA. So this should be something that obviously they could appeal, but the question is, how soon will OAH get to it? So there's 2 problems here. One is that appeals have going back to March. Some of them have not been relayed by the Employment Security Department to OAH. What that means is when ESD gets your appeal, and that's an appeal that could just say, I disagree with this determination and I wish to appeal it. ESD gets that, then they put together a packet. It's not a complicated process, but it has the discussions you may have had with an adjudicator. It has your determination, any other correspondence you might have had with ESD. That goes in a package to OAH. Under normal circumstances, that takes a few days, but lately it's been taking weeks, 2 months. So we don't have an explanation for this. It is very untraditional for this to be happening. Normally, ESD does not sit on those appeals. I've talked with not only John, but prior directors of the Unemployment Law Project. None of them have ever seen this happen before. ESD's explanation is, we like to see if there's any new information, so see if we can do a redetermination in-house. And they have been redetermining many of these claims, these appeals, for reasons that look like, why didn't they do it that way in the first place? Up to 50,000 of these appeals have been redetermined to award benefits to the claimant, which we think is great for the claimant, but it's inexplicable, because what it means is that there was some mistake was made at some point, and the person had to go through months thinking that they had a denied claim. and they didn't get any resolution for extra months. So that's one issue. They're not getting sent to OAH. Now when they're going to OAH, because OAH has so many claims, so many appeals it's dealing with, 7,000 in September. It's taking up to 6 weeks, according to OAH, to get a hearing scheduled. So unfortunately, we can't be very optimistic about getting a quick resolution on these appeals. And this is something we've been steadily harassing ESD about, to try to get an explanation, to see if we can get some action on this. It's really a problem.
Okay, thank you, Anne. Thanks for that context. If a person's unemployment was affected by being taken off a schedule, but the company they worked for contracted with physical facilities that never closed, and the claimant could not answer yes to any of the questions, would it make a difference to appeal?
I'm not sure I understand. Maybe it's, do you understand that, Benas? I'm not sure I understand what they're really asking about.
I'm wondering if it's related to the able and available questions. It looks like the claimant was able and available, but the employer took them off the schedule with the company they were working for. I would say if someone is denied, yes, then you should appeal, because that is an opportunity to preserve your rights to
Right.
keep moving the process forward. You don't want to let that lapse, and there is a 30-day timeline on that. I will provide my contact information.
Great.
So please feel free. It's an anonymous question, so whoever submitted the question, please reach out to me directly, and I'd be happy to assist you with a little more information. Okay, let's talk about base year. How would ESD reconfigure your base year for benefits, since we are now in a new quarter? We have a participant who was approved in March for benefits, but their claims each week are paid 0 due to excess earnings. And they're wondering if since they are still partially unemployed, if they can still get a payout.
So if you're getting 0 due to excess earnings, that generally means you're earning, 75% of what you earn is going to be subtracted from your benefit. So I'm not sure how base year would affect that. So this may be something that you might want to write to us as well, because I'm not sure I'm understanding what the connection would be with base year.
Okay, great. All right. Let's see. Thank you for answering my question. To clarify, I originally did file for UI. I waited to get rejected, then filed for PUA, and that was adjudicated. Then the participant was paid weekly claims that they were filed under PUA. Suddenly the UI claim was reopened online. So when they file weekly claims, it no longer gets filed under PUA, but gets filed under UI. I feel like the whole problem is just their software. The case has been kicked back to UI when it's really PUA, and that their understanding is that's why they are no longer eligible.
So they have been telling us that this could be happening multiple times. You could be going from regular UI to PUA and then back again, because your qualifying reason, if for some reason they perceive it as not being COVID connected, then you can't continue qualifying for PUA. So without seeing the individual facts, it'd be hard to guess what was going on there. But they have said this could happen several times, and so it may be part of their software, a software quirk on top of that. But it's also something that they're saying is part of their policy. I'm not sure where the information may be coming from, but they have said, I've asked them directly, can you go back and forth? And they said yes.
Okay, great. I will also ask that participant to reach out to us for more specifics. We have a participant with us, a really wonderful gentleman I've been working with, and he has a great question. Suppose I contract informally via email to write a freelance article for a magazine. I work on it, research and phone interviews in week A, but I'm not paid until week F. Also, I'm paid per word, and that depends on the final draft accepted by the editor. So I cannot tell ESD how much I was or will be paid until the final acceptance of my article. How do I report, have you worked for any employer this week, on my weekly claims?
Yeah, and that's a very tricky question, because I believe the application, the claims question has not changed. It says, have you done any work this week for pay, even if you have not been paid? That is not geared to somebody who's self-employed. So I would, in the spirit of going with the intent of the question, I would consider that what ESD is looking for is your net income in the week that you and you have to estimate this yourself. This is not something you can pinpoint in an exact way without knowing your whole year's income and whole year's expenses, and that's not possible to even know. So I personally would not feel I was taking a big risk by saying, no, my net income this week was 0 because I had expenses. I did not receive any money. So I just think that would be how I would interpret it. Now, I can't guarantee that they're going to see it that way, but they're dealing with a system that is set up for regular benefits, but they're trying to shoehorn PUA requirements into that. So I would look at the question that way and say, I have no income to report because I don't know, you won't know the net income.
Correct, Anne. I agree with that. And I would say, I think the question, have you worked for any employer this week, goes on the presumption that when you're working, you're paid either an hourly or a salary wage. And
Exactly.
then the next prompt is, how much did you earn? That question doesn't apply for PUA because an independent contractor or self-employed individual can work for someone. Well, it also says the word employer, can work for a client but not get paid. And I think Anne is correct. Use good judgment, but also interpret the question a little more broadly than how it's written. The system wasn't necessarily altered or designed for PUA, and best to probably, it's probably not a bad idea to report the income when you've received the income during that week. That is all the questions we have at this time. We apologize for John having some technical difficulties. His microphone had stopped working, but he is available to reach out personally. I have provided his contact information to a few of the participants today. You can certainly find us on our website, and we'll be back here next Monday. If you have any additional questions, we look forward to answering them. Thank you, everyone, for joining us.
Brew review on Vine Thursday night.
Brew review on Vine, or drop the link in the chat box. It's the first one. We definitely look forward to having you join us on Thursday. Thanks, everyone. Have a great week.
Thank you.
Bye-bye.